All right. Welcome to the Custody Clinic presented by Legal Aid of North Carolina. While Legal Aid is unable to offer representation in most custody cases, this presentation will provide you with an overview of custody law in North Carolina and guidance on how to file a custody complaint on your own. The presentation will also address the impact of the COVID-19 emergency on filing for custody at this time. The presentation will explain custody law as it applies to both parents and non-parents. Our presenter today is Dietrich McMillan. Dietrich is a managing attorney for the Legal Aid of North Carolina Durham Henderson offices. Following the presentation, you will have an opportunity to ask the attorney general questions about the law. Please keep your questions as general as possible, as we are unable to provide you with legal advice specific to the facts of your case. If you're watching in Zoom, you can put questions in the Q&A feature, and if you're watching on Facebook, you can put your questions in the comments. Thank you for attending today's clinic.
Good afternoon, everyone. Thank you again for attending our Legal Aid of North Carolina Child Custody Clinic. Again, I am attorney Dietrich McMillan. I am the managing attorney over the Durham Henderson office here in North Carolina. And as our presenter stated today, just a few minutes ago, we will be going over child custody and being able to file for child custody. We will also go into some detail about if you are looking to file for emergency custody and or if you are a third party that is not a parent looking for custody. Please be reminded that I am not able to answer specific questions as we do not represent you, and ethically I cannot give you legal advice unless I am your attorney. This clinic is not designed for us to represent you, but to just give you general advice. So please try to keep your questions as general as possible. So we're going to go ahead and get started with the custody clinic. Just a little bit about Legal Aid in North Carolina. We are a statewide nonprofit law firm providing legal services for free in civil matters to low-income people to help them have equal access to justice and to also help remove legal barriers to economic opportunity. There are various areas of practices that we do. We do not do all civil law. We do housing, employment, education, domestic violence, disaster relief, consumer benefits. We also try to provide in those areas in which we do not do representation by providing monthly clinics in criminal record expungement, child custody and visitation, employee rights, healthcare power of attorney and living wills, Medicaid managed care, simple divorces, Social Security disability, tenants' rights. You can find most of this information on our website at legalaidnc.org, or if you are in need of assistance with some of the civil legal areas that we have just stated, you may call our Legal Aid helpline at 1-866-219-5262. Again, that's 1-866-219-LANC or 5262. Again, Legal Aid does not represent you. The intent of this clinic is to help you file your documents on your own and to represent yourself in court when you're seeking custody or visitation. If you already have a case pending, we will not go over how to file a motion to modify custody. So what laws, where can you find the law for custody for North Carolina? In the North Carolina General Statutes, custody laws are based in the Section 50, which is styled as divorce and alimony. So there are provisions under Section 50 that deal with custody action. I believe it's around 50-13. Section 50-13.1 speaks to custody and mediation. You also have the North Carolina General Statute, Section 50A, which speaks to child custody concerning jurisdiction and deployed parents. And those are parents that are away in the military. So what is the legal standard? For parents, it is the best interest of the child. What the courts will look at when determining what is in the best interest is who has been the primary caretaker, what type of discipline is given to the child, what is your work schedule, who's providing for the child physically, emotionally, as well as educationally. Are there spiritual needs of the child that are being fulfilled? What is the parent's character? Are there other persons living in the home? And who are they and what are their characters? Which parent can foster a feeling of love towards the other parent? These are just a few things that the judges look at when determining what is in the best interest of the child. Now, the legal standard, if you are a non-parent seeking for custody, you must show that the child is, that the parent is unfit and have acted against his or her legal constitutional rights. Who can sue? Any parent, relative, person, agency, organization, institution claiming a right to custody, or someone with a relationship to the child. So just about anybody can sue for custody of the child if they can establish that there is some type of relationship. Where do you file? You file in the county in which either you reside or the county in which the child or other party reside. And that will be in district court. When to file? Generally at any time after the parties are separated and or after the child is born. The child must be a resident of North Carolina for at least 6 months prior to filing to the courts for jurisdiction. Now, if the child is under 6 months and you believe you need to file for custody, then the North Carolina can assume jurisdiction where the child was born, if it was born here in North Carolina. Let's go over some definitions before we get into filing the complaint. So what is the complaint? The complaint is a court action started against someone that asks for specific relief. So a plaintiff starts the action by filing a complaint. Plaintiff is the person that starts the action and is asking for relief from the court. If you file this custody action, then you are the plaintiff, and you will always be the plaintiff in this case. You will not change whether you're plaintiff or defendant. Even if the defendant files something against you, you will still be the plaintiff in any other proceedings that are filed. So just remember, if you're filing this action, your name will always go over where the plaintiff is. The defendant is the person being sued. What is an answer? That is defendant's response to the plaintiff's complaint. And the defendant may also file a counterclaim, which is essentially the defendant's complaint against the plaintiff. Usually the answer is filed at the same time and in the same document as the counterclaim. And you will often hear it be referred to as the answer and counterclaim. Pro se. Pro se is just a fancy word to say that you're on your own, that you're proceeding in court without an attorney. Custody, parental responsibility of a child. And there are different types of custody. You have physical and you have legal custody. Physical custody is where the body of the child is residing or at. The legal custody is the ability to make decisions concerning the child's welfare. Along with that, there are different ways in which you can have physical and or legal custody. One is exclusive, or sometimes called sole custody. And this person, whoever is awarded exclusive or sole custody, has both physical and legal custody of the child. That means that they have the child with them and they have all of the rights to make the legal decisions concerning the child. The legal decisions will include education, medical, and things on that line. Now, understand that even if that person has exclusive sole custody, the other parent may still have some type of visitation privileges. Now, exclusive custody is a very hard thing to get in North Carolina, even if the parent has not been the best parent. So we're going to talk about joint custody. And this is where parents share the care of the child together. And you have primary custody and you have secondary custody. Primary custody is where one parent has the child the most number of nights during the year. Generally, that parent has the final say concerning decisions about the child. Secondary custody is where the parent has limited number of nights and is usually equated or called visitation. And visitation is when the non-custodial parent has the right to see the child, and the amount and type is determined on the child's age, how close the parents live to each other, and it's usually on a schedule. Now, there are really two types of visitation: supervised and unsupervised. Supervised means that the parent will have to have someone with him or her during the time they visit with the child. And generally, this is given when the judge feels or believes that the other parent may harm or may not do what is best for the child while in his or her care. Unsupervised is just that, is not supervised. The parent has free reign to watch the child, to have the child, to take care of the child during his or her visitation period. There are two types of joint custody. You have equal custody and you have split custody. Equal custody means that both parents have equal number of nights throughout the year, and both have the ability to make the legal decisions concerning the minor child. And sometimes, depending on the judge, that judge may say that one parent or the other parent will have the final say so if they cannot come to an agreement. But generally, these are when parents are able to get along and they understand the importance of the child being in both of their lives and having as much time with each of the parents. The next type is split. Now, this is where the parents share the child under primary or secondary custodianship, as we described before. One parent will have primary custody, the other parent will have secondary custody, limiting the number of nights that that parent has. Until an order is written, both parents have equal rights. This is regardless if both parents' name is on a birth certificate or not. Both parents will have equal rights. Understand, without an order, law enforcement will not help either parent retrieve a child from the other parent. There must be a court order in place. If your parental rights have been previously terminated, you do not have the right to sue for custody or visitation of the child. You have lost those rights. Understand that child support and child custody are separate actions and can be litigated separately. One action does not depend on the other. If the parent is not paying child support, that does not exclude that parent from having custody or visitation of that child, and vice versa. Again, child support does not have to be paid to have custody or visitation. These are two separate actions in North Carolina. Now, before you file, really think about whether or not you need to file. You do not need to file to get child support. You do not need to file to get state assistance. You do not need to file for school enrollment, medical insurance, or temporary child care. You need to look to see if there is a reasonable risk the other parent will try to take the child. There are some drawbacks to filing. And in reality, we all must understand the pros and cons. And one con is that it is very time consuming. There will be numerous trips to the courthouse. The court will examine every aspect of your personal life. They will examine your medical history, your criminal record, your character, any significant others that you're either dating or living with, and so on and so forth. Also, if the parent is disinterested at this time and is not really going after seeing or getting the child, when an action is filed, that disinterested parent will all of a sudden generally get interested and now wants to have some time with the child. And all in all, the court's duty is to do what is best for the child. And generally, that is the child will have access to both parents, no matter how you feel about each other. And so you may not like what the court may order concerning the other parent seeing the child. So always do a self-evaluation. Look at your employment. And one of the things the judges will look at is stability, employment, housing. Are there any pending and past criminal charges? This does not bar you from being a good parent. It doesn't say that you can't take care of your child, but just know that they may come up and the judge will look at that and give it some weight as to whether or not that will hinder the best interests of the child. Do you have a driver's license? Some people say, well, what does driving have to do with having custody of the child? Unfortunately, in North Carolina, and based on my experience, the judges do care if you have a valid driver's license. Can you get around with the child? Can you get the child to medical appointments? Can you get the child to school if he or she misses the bus? You know, how do you propose to get around not having a driver's license? It is not something that you have to 100% have, but it certainly helps to have a valid driver's license that is not revoked and you are driving legally. What is your living situation? What is your housing like? You know, how many people are living in your home? Is the home safe? Are you living with a boyfriend or girlfriend? How does that child interact with that person? Do you have a spouse that is not the father? How does he or she, or that is not the other parent, how does he or she interact with the children? So the judge will look at all of these things when determining the best interest of the child. Mental stability. You know, are you on your medication? Do you take it regularly? This is not a bar to say you can't have your children. This is not something to say that you are not a good parent, but are you doing what is medically necessary to make sure that you remain stable? Are there any prior court orders? The judges will look at that to see if you've agreed to other things. What was going on before? Do you have a history of bad orders or having things issued against you? And then the judge will look at whether or not it's best interest for that child, for that parent to have custody or visitation. You also want to determine whether or not you need a lawyer or if you can do this pro se. So ask yourself the following questions. Will the other parent be cooperative or will they fight for custody? Is the other parent likely to get a lawyer? If she or he gets a lawyer, will you be able to get one? If you answered yes to any of these, or the parent is going to be non-cooperative, you may want to get a lawyer, but you also should get a lawyer if your custody case is contested and the other side has an attorney that just levels the field. Or after reading the entire packet, you feel that you still need help filing for custody. You want to make sure that you do everything that you can to put yourself in the best position, dotting every I and crossing every T. So are you ready to file for custody? We're going to look at the steps to proceed pro se. We're going to look at preparing the documents, filing, service, mediation, and setting this on the calendar and preparing for hearing. So the first step is preparing and gathering all of your documents. As you can see, there are 7 documents that you will need to begin preparing, and we'll go over each one of these. You will notice over in on the right-hand side where it is a little reddish, these documents can actually be found on the website nccourts.gov under forms. If you type in the name of the form will come up and you should be able to get it in different languages, but English will come up first. So each of the forms that you see that have nccourts.gov on the side can be found on the website. The blue, you must prepare it on your own, or it is a local form. And the local forms may or may not be on the website. I do believe most counties do have forms for their local for their local filings. But we'll go over each one. We'll go over the petition to sue, the domestic civil action cover sheet, service member affidavit, civil summons, complaint with verification, affidavit as to status of minor child, and notice of mediation. Understand that the documents must be typed, or you must print neatly in black or blue ink. Do not write in red, pink, or green, black or blue, or it will not be accepted. So let's get started. The first document, let me go back a little bit. This is the order in which you would want to present your documents to the clerk. And we'll go over this again at the end when it's time to file these documents. So the first document is the petition to sue or appeal as an indigent. This form is for if you cannot afford the filing fee. You can use this form to request that the fee be waived or that you do not have to pay the filing fee. If you receive food stamps, TANF, or SSI, or if you're represented by legal services, which will not be in these cases, you are eligible to file for free. It is not in the discretion of the clerk. You are able to file for free. I advise you to take your food stamps card, your TANF, or any documents with SSI on it in case they ask for it. Be honest. If you're not honest, because you do have to verify and notarize this paper, then the courts can hold you in contempt of court, which is a crime, and it is a criminal proceeding for giving false information. Also, if you do not receive any of these benefits, you are able to ask for an affidavit of indigency and fill out and put on there your financial status. If you're out of work and you don't have any money to pay, but it's temporary and you know that you're not receiving food stamps, TANF, or SSI, you can still ask the clerk to waive the fee, and they will give you a form for you to fill out your income. So this is the petition to proceed. It may look a little blurry because we try to blow it up so that you can see it better. And we're going to go over each of the components and what you will need to fill out. So we're going to start here at the top right-hand corner where it says file number. You just leave that blank until you take all of your documents to the courthouse. You will not have a file number. The clerk will issue you one once your documents are filed. You will check this box that says district, and that's right here in the right-hand side. All custody actions are in district court. They are not in superior court. There is no jury trial for custody. Again, the judge has the discretion of determining what is in the best interest of the child. So we're going to go over to the left-hand side at the top. And here, this is the county in which you will file. Whether it's Durham, Robeson, wherever you are in North Carolina, this is the county where you intend to file is here. You, if you're starting this action, will file as the plaintiff. You put your name here and the defendant's name here. Because this is the first and you're starting the action, you would click or check on this first box, which says petition to assert claims. Again, this file can be found under nccourts.gov. This document can be found under nccourts.gov. You type in this name, petition to proceed as an indigent, it will pop up and you can actually fill it out, save it, and then print it, a typed copy, nccourts.gov. Then you will come down and about midway, and you would check whatever boxes are applicable. So if you are presently a recipient of Supplemental Nutrition Assistance Program, SNAP, or food stamps, check the box. If you're receiving temporary assistance for needy families, check the box. If you are receiving supplemental security income, check the box. If you are receiving none of these, then you will go down to this last box and state and check, although I am not a recipient of SNAP food stamps, TANF, or SSI, nor am I represented by legal services, I am financially unable to advance the cost of filing this action. You check that box. Once you have checked all of the boxes, you go over here to the right you put the date, you sign it. I'm sorry, you put the date and you put your name and address. Before you sign, it will need to be notarized. You need to be in front of a notary for notarization. So hold off on signing it until you have all of your paperwork completed and ready to be notarized, that need to be notarized, so you can do everything all at once. Again, this petition to proceed as an indigent needs to be notarized. Do not sign until you are in front of a notary. So then once you have this paper and it's ready to be given to the clerk with your other documents, the clerk will look at it. She will verify that you are authorized to file and have your filing fees waived. She would check the box, or he would check the box, date, sign it, and file stamp it with the other documents. If the clerk denies this petition, then you will have to pay filing fees, and the clerk can tell you what the filing fees are at the time you are ready to file. The next document in the series is your civil action cover sheet. This cover sheet just tells the clerk why you're filing, what you are filing, and gives information on that filing. Again, up in the top right-hand corner, you will have the file number. The file number will be given to you when you complete all your documents and you take it to the clerk's office and you're ready to file. The clerk will put the file number there for you. The county, the same county as the petition to proceed as an indigent, you need to put here. This first box, you put your name and address of plaintiff. That is you that is filing the custody action, your name and address. Then you come down to the name of defendant and you put the name of the defendant here. Go over to the right and click the box initial filing. Here where it says jury demanded in pleading, you put no. There are no jury trials in custody actions. And then you put your name and address once again over here in the right because you're representing yourself. Put a telephone number in the event the clerk needs to contact you. It could be a home number or it could be a cellular number. Then you come down to type of pleading, and this will be a complaint. So you would check the box complaint. Then you come over to the right, claims for relief. You're asking for custody. In the event that you're just seeking visitation, you can click the box visitation. So one of these boxes need to be checked, custody or visitation. Then you date, and you can go ahead and sign the cover sheet. This does not need to be notarized. The cover sheet does not need to be notarized. So go ahead and date and sign. The next form is a service member affidavit. This is used to verify a party's military status. And in this case, as the plaintiff, you will need to verify the defendant's military status. Is the defendant in the military? Is he deployed? How do you know? Just a little bit about this. This is a relief act that has been enacted not too long ago to protect service members' legal rights during active duty. The Relief Act applies to members of the Army, Navy, Air Force, Marine Corps, and National Guard that are on duty. If a service member is on active duty, the court cannot enter any order until the court appoints an attorney to represent that service member. Again, if that party is on active duty, in most instances, the case will be stayed or postponed until a later date, meaning the courts will not hear the case until that person is off of active duty or is able to appear in court. This is so that orders are not entered against people in the military serving our countries who cannot appear due to military duties. If you are filing a new lawsuit, such as in this custody complaint, you have to complete and file the Relief Act affidavit in order to get your actions filed. It is mandatory. It is not an option. This is a closer look. Again, I apologize that it's a little blurry, but we wanted to make sure you could see it. File number, again, the clerk will issue the file number when you file. County, the same county that you previously put in is what you would put here. You will put your name as the plaintiff and address. Then you will put the name and address of the defendant. Then you will go to number 1, and you will check which one is most relevant to you, whether you have personal knowledge that the defendant is in the military or is in military service, whether you have personal knowledge that he is not or she is not, or you don't know. You're unable to determine whether the person is in a military service. So you check one of those boxes. Then you go to paragraph 2, and there is a website that you can go to, and we'll get that into number 3. And you will let the courts know as of today or as the time that you sign this affidavit, whether or not you have received a copy of a military order from the defendant. So you would check either I have or have not. Then you can go to number 3 and let the courts know whether or not you have gone to this website, scra.dmdc.osd.mil/ to determine whether the defendant is in federal military service. This form is also at the nccourts.gov website, and more than likely they will have a hyperlink that you can click onto to take you to that website. So I encourage you, if you're able to use the internet, and you can go to nccourts.gov, all of the forms that we have talked about so far are on that website, nccourts.gov, nccourts.gov. If you do use that website and you pull up a record, or you pull up saying that there is no record, you can print that off and you can attach what you have pulled up to this affidavit. If you do not use the website, you go to number 4 and you put in facts that support your statement as to defendant's military service. How do you know if the defendant is in the military, or how do you know that the defendant is not in the military? You could say something as simple as, I know the defendant is not in the military because he is 90 years old, or he's 95 years old, or she is not able to be in the military because she just had the baby. Why do you know or do not know that the person is in the military or not? Then you will come down and you will sign your date, sign. This does not need to be notarized, and type or print your name. Again, this form is on nccourts.gov. So now we're going to get into the actual filing or the paperwork for the complaint. And the first part of the complaint is the civil summons. And the summons is used to serve the defendant, summoning him or her to court to tell the judge why or why not they should give the plaintiff the relief they asked for. With the civil summons, there is a front and a back. Sometimes you will see there'll be two pages, and that's fine. Just staple them together, but there's a front and back to the summons. And with the summons, and we'll go over this a little bit later as well, there are 3 copies that you will need. You will need 2 yellow and 1 white. If you do not have yellow paper or cannot get access to the yellow civil summons, they should have them at the courthouse in the clerk's office, right for service on one of the copies. And that copy will be for the defendant. The defendant will always get a yellow copy. This gives him or her instructions on what to do when they have been served with the complaint. You will keep the white copy, or you can leave it in the clerk's office if you desire to do so. But you will also have a copy for yourself for the yellow copy. Always make sure whatever you're filing, you keep a copy as well. So this is the civil summons. And again, file number will be given to you when you file your case. County, the county is where you're filing, just as you did in all of the other documents. Again, this document can be found at nccourts.gov. I really want you to get familiar with that website, nccourts.gov. It will give you forms, what's going on at your courthouse, local rules, local forms, everything that you need to know about the court system in your county will be on that website, nccourts.gov. The civil summons can be found on the nccourts.gov website. You will fill out your name, address, city, state, and zip. Versus the defendant, you will put his or her name right here on the left-hand side. And then under that, you will again write the defendant's name and address. This tells the sheriff's department or whomever where to serve the documents. So you have to, and you need to have an address for the defendant. Some clerk's offices, unfortunately, will not allow you to file unless you have an address for the defendant. So even if it's a last known address, put it on there. This box right here basically tells the defendant what he or she needs to do when they receive these papers. It gives a warning that these papers are important. You have 30 days to answer. You may want to talk to an attorney. If you do not speak English, then maybe try to find someone that can interpret or translate the documents for you. Then it just tells them that they have a civil action that has been started against them. And if they do not answer or appear, then the plaintiff may be able to get the relief that he or she requested. The last box you will need to fill out, sorry about that. The last box you will need to fill out is the name and address of you, the plaintiff. Once again, name and address. Anything else that needs to be filled out, the clerk will fill it out. They will issue the summons here, they will do the time, and they will sign it and check one of these boxes. So all you need to do is just fill out all of this that's on the left-hand side, and the clerk will fill out the other boxes that is needed. So now we get to the complaint. This is not the right one. So this is the complaint for custody, visitation, and child support. Try not to leave any blank spaces unless you're sure it doesn't apply. And if I can have one moment, I'm going to take a little break and let you with those documents. Okay, so you may be more familiar with this particular form. This is the complaint for custody and visitation that we'll be using on today. And this is, again, not on the website. There are no forms for this. This is the only form that you have, or you can type it up yourself. But you must have all of these things that are in this form. This is the one that we stated that you must do on your own. This is not found on the nccourts.gov website. So the form you may have in front of you, the file number, again, leave blank. That will be filled in when you file it with the clerk. Then you go here, and again, you put the county in which you're filing. Here you put the name of the plaintiff, which should be you. Name of defendant. And I want to say that when you're putting the name on every document, put it and write it the same way. If you write John D. Smith on all of the other documents, make sure you put John D. Smith on this and every other document that you're filing. Here on the side, you will click whether it's custody or visitation. The first line, the number 1, this is where you tell the judge in the court what county and state you live in. And you will put the blank county, whatever county you're living in, and that is in the state of North Carolina. Again, you can file your complaint where you live or where the child lives. The defendant is a resident and citizen of what county and what state? The defendant, as long as you're here and you've been here for 6 months or more, or the child has been here for 6 months or more, the defendant can reside out of state. So you will fill in the county and the state. Then you would check whether you are married and living separate apart, divorced, or never been married. Number 4, you will put the parties are the parents of the following children. And you will list the names of the children. Okay, so you'll list the name and date of birth. Let me correct that. Name and date of birth of each of the kids that you are seeking custody of. Now, if you are not a parent and you're suing for custody, you can put here, the defendant is the parent of the following children. So this is your complaint. You can neatly mark it out and put defendant right here where it says party, and still list the names of the children. North Carolina requires, when you're filing or requesting custody, that you put in where the children or child has lived in the past 5 years. So you would take each of the kids and you would list them separately as to where they lived for the past 5 years. Even if they are all the same age, or if you have twins, you need to list them separately and list where they have lived for the past 5 years, even though it may be exactly alike. So you would start with the first minor child, and a minor child is anyone under the age of 18. You will put their date of birth, and you would say live as follows. And you always start with the most current address. You put the address, the name of the person lived with, and the present address of the person that they were living with. And you do that for the 5 years. If you need more space, then go ahead and neatly write or type in the spaces. For each child, you also need to let the courts know whether or not there are other custody actions or have been other custody actions. Generally, you cannot file a new custody action if there is already a custody action for that particular child. And so you need to let the courts know that you participated in litigation concerning the custody of the above named child. Okay, you need to let them know the name of court, the case number, and the date of decision. Okay. You need to let the courts know if there is any information of a lawsuit concerning the above named child in a court in North Carolina or another state. Maybe someone else tried to file for custody outside of the parents. You need to let the courts know. Or maybe social services filed for custody of the child in another state. The courts need to know, because they have to determine whether they can assume jurisdiction, or if that court that previously has made a decision, or the type of decision that was made has the right jurisdiction, meaning the right to actually hear the new custody case. The last box states, I know if a person is listed below who has physical custody, claim visitation rights with the respect of the above named child. This is someone that you may not have listed as a plaintiff or defendant that might have the physical custody of the child, or may think they have custody, or may think they have visitation privileges or rights to the child. And you need to address those persons, put those persons there. If you have a second child, you do the same thing for each of the children. And at the end, if you have more than the number of children that is allowed on this, There is an option that you can use for other children, 3, 4, and 5, and so forth. Again, you fill out the same information if that child has been a part of any type of custody decision or proceeding. Number 6, the plaintiff is a fit and proper person to have custody of the children or child, and it is in the best interest that the plaintiff be awarded. And if you're asking for custody, you can check custody. If you're asking for visitation, you can ask for visitation. Just because you ask for one or the other doesn't mean that the court is going to deny visitation. So if you ask for custody, but the court says, well, I think you should only get visitation, the courts can still give you visitation. Number 7, the parties have been unable to agree on a custody and visitation schedule concerning the children. You don't need to do anything there. Then you want to let the courts know that you believe they do have jurisdiction to hear the custody case because the children have lived in North Carolina for past 6 months, or if the child is under 6 months old, have lived in North Carolina since his or her birth, or for a majority of the child's life. Now, I don't have this on the screen, but if you are a person that is a grandparent or a third-party person asking for custody of a child against the parents, you will need to add in there that the defendant is not a fit and proper person to have custody or visitation of the minor children. That is one of the requirements if you are not a parent and you're seeking custody of the child. And I'll repeat that again. The defendant or defendants, if you're suing both parents, are not fit and proper persons to have custody or visitation of the minor child or children. You have to allege that they are not fit, that they are unfit parents. And you can add that either here as number 9, or you can get another sheet of paper and put complaint continued and add the defendant or defendants are not fit and proper persons to have custody or visitation of the minor children. If you're seeking emergency custody, you will want to put the same language and then explain why. Do not go into a whole book, but just put 1, the defendant is not stable. 2, the defendant has caused the child or children harm if you're asking for emergency custody. Now, with emergency custody, the court will determine whether or not if the child is with the other party, if that child will be harmed or put into some type of danger, or if the other party will try to abscond or run away and hide the child from you. It is very limited. And you will have to show the courts in an emergency situation that one of those things will happen, that the child is going to be harmed physically, or that the parent is going to run away with the child and you fear you will never see that child again. The last part is for an order giving you temporary and permanent custody or temporary and permanent visitation. You check one of those boxes. And temporary just means that I need to get something quicker. I need to get something sooner rather than later. And that's where your emergency provisions can come into, because you're asking for temporary custody. If you get emergency, or if you request emergency custody, it is temporary. It will be temporary. So you would need to just check temporary and permanent custody. And then this box is just telling the courts that anything else that you believe that I did not ask for, that is just and lawful for the child. Then you will want to date, sign. Please put your telephone number, and this is public record, so make sure it's a telephone number that you don't mind the public having. It will not be blocked out. This is really for the clerk's usage in case something happens and court has to close immediately the day before your court date. And your mailing address. Please put your mailing address. That is required as well, so that the clerks can send you notices or send you whatever needs to be sent to you, as well as the other party. The last part of the complaint, and this is a part of the complaint, is the verification page. This is the page in which you're saying that what I put into the complaint is true to the best of my knowledge. And this has to be signed in front of a notary. You can sign the bottom of the complaint here, but then the verification stating that the complaint is true to the best of your knowledge has to be signed in front of a notary. And again, you put your county, you put your name, just as you have it in the top of the other proceedings, paperwork, the date, and then when you get in front of the notary, you sign, and the notary will do the rest. So the next part is the affidavit as to status of minor child. And this is for each child that is involved in the court case. Remember where you put the box where you put where the child has lived for 5 years? This is another form that the nccourts.gov has given that you also fill out. And if you have more than 2 kids in which the complaint that we have for you allows, you can also make sure that each of the other children, 3, 4, and 5, have the affidavit as to the status of minor child. So every child, if you have 5 kids, you need 5 affidavits. And this has the same exact information that is on the boxes on the complaint. So for child 1 and 2, you're just filling this out again. And on this, you will need to have it notarized. So you will put the date, your signature in front of a notary, name of affiant, which is you, and the relationship to the child. So if you're the mother, you put the mother. If you're the father, you put the father. If you're the grandmother, grandfather, aunt, whomever you are, what your relationship to the child is. Okay, so again, this affidavit as to the status of minor child is on the nccourts.gov website, and you need to fill it out and have it notarized when you have the other documents notarized. So far you have the petition to sue as an indigent. So far you have the verification page of the complaint and the affidavit as to status of minor child that needs to be notarized. So next we'll go into the cover sheet for custody or mediation. Now, these sheets are local to your area. They are specific to your area. You can go to nccourts.gov and click courts, and then find your county, okay? Then look for rules and forms under that county and click that in, and then scroll down and look for anything that says district court mediation. You can also call the clerk in the county where you are filing and see if they have pre-printed forms for you to go pick up. This is a sample of Robeson County's cover sheet for mediation. Okay, some counties may have a mediation letter for the parents, a notice of mediation orientation, and a cover sheet, such as in Vance County. They have a custody mediation cover sheet, and they're very easy to fill out. All of them have basically all of the same information. You're just going to give your information as plaintiff, your address, defendant's name, their address, phone numbers, emails, so that the mediator can get in contact with you. Here, our mediator asks if there's any pending or resolved civil or criminal domestic violence cases, and you check yes or no. Has this case been to custody mediation before? Excuse me, you check yes or no. And does this case need an interpreter? Okay, so these documents are specific to each county. They are not all the same, like the civil summons and the petition to sue as an indigent. There's also maybe a letter. Vance County has a letter for their parents. And then you want to fill out a notice for custody mediation orientation, and you can get all of the information from the clerk's office as to when that date is, or you can call the custody mediation office. And they have left the information so that you can get the next date for orientation. So what is mediation? Mediation is where a third party that is neutral will sit down with you and the other party, the defendant, and see if they can help you come to an agreement as to what is best for the child concerning custody and visitation. That is all they do. They do not do child support. They do not divide property. They just deal with the custody of the child and try to see if the parents can come to an agreement as to their minor child. Also, I do want to say with mediation, there are two ways that you can have mediation waived, meaning that you do not have to participate in mediation. It is mandatory in all counties in North Carolina. And the first way that you can have mediation waived is if there has been domestic violence, which is why this question on this form is asked. So the mediator will know, and she will call or talk to you and determine whether or not you can even do a Zoom call, or if it's best not to go forward with the mediation. The other way to have mediation waived is if one of the parties live 50 miles outside of the courthouse. This may not be a good waiver at this time because mediation is for the most part being done by Zoom or WebEx. And so if the parties have access to Zoom or WebEx, then the mediator is allowed to do the orientation and to do the mediation via Zoom or WebEx or over the internet. But those are the only two ways that you can get out of doing mediation. And sometimes the judge, even knowing that there is domestic violence, may order it to mediation if they feel that the mediator can reasonably keep the parties safe, meaning they could be in separate rooms, they could do it over the internet, where they can be in different breakout rooms or what have you. Mediation in North Carolina has been highly successful because it gives the parents an opportunity to sit down, talk with someone that doesn't know either party, that doesn't know the child, but is able to help the parties come to a compromise or a solution that may be better than allowing another person to only take a few hours of testimony to determine the life of a child and where that child is going to be. And so mediation is strongly, strongly encouraged. So once, and we'll talk a little bit more about mediation if we need to. So once you have got all of these papers done, what do you do now? So you get them, you get them notarized. Again, what documents need to be notarized? The petition to sue as an indigent, the verification page on the complaint, and the affidavit as to the status of the minor child. They all need to be signed in front of a notary. Once you have it signed in front of a notary, then you can make copies. Again, I would say make copies of everything and make sure you have a copy of everything that you file. So with the petition to sue or appeal as an indigent, you will have one original and one copy. The domestic civil action cover sheet, you really only need one original, but go ahead and make that extra copy for yourself. The same thing with the service member affidavit, one original and make a copy for yourself. The civil summons, you will need one white copy and two yellow copies. If you cannot get yellow paper or get it on yellow, then just write for service on the extra copies. The complaint with verification, you will need one original and two copies. The same with the affidavit as to the status of minor child. For each one original and two copies. The notice of mediation, one original and two copies. So for number 5, 6, and 7, you will want all of those to be attached. So you will have a complaint, all of your affidavits as to status of minor child, and notice of mediation. Put all the originals together and put them together. The two copies, put them all together. And the clerk will go and don't staple them, just put them all together, and the clerk will go through and file stamp all those that need to be file stamped. You're going to give all the documents to the clerk. Now, if you're not using the petition to sue or that petition is denied, you may have to pay, or you will have to pay the filing fee. And that filing fee, I will ask the clerk what the filing fee is, because sometimes the legislature will change how much that fee may be. When you file, the clerks will keep the originals and give you the 2 copies back. One copy is for you, and the other copy is for serving the defendant. When you're filing, you can ask the clerk, how do you get it to the sheriff? If that's the method of service, which we're going to go into next, how do you get it served by the sheriff? Some clerk's offices will have a sheriff box, and the clerks will be happy to write, to put that in the sheriff's box for you. If you have a petition and it was approved, your sheriff fee is also waived. Otherwise, you will have to pay for the sheriff to serve, and that's between $30 and $50, I believe. And so what the clerk will put or give to the sheriff, and what you would have to do if you have to take it to the sheriff's office, is 1 yellow summons, your complaint, your minor child affidavit, and your mediation papers all need to go to the sheriff. As well as, and I did not put this on here, the white summons, the clerk will give that back to you if they do not put it in the sheriff's box for you. And we'll talk about that a little bit later. Remember, the clerk's office will not accept personal checks. So if you have to pay any fees, you must use cash or money orders. I believe some clerks do have credit cards. I would encourage you to call the clerks and see if they accept credit cards as well. Please, please, please remember, clerks are not lawyers and they cannot give you legal advice. They may be able to give you documents to fill out, but they cannot tell you how to fill them out. So that brings us to part 3. And we talked a little bit about serving with the sheriff's department, but let's look at some other ways to serve with the defendant. But first, let's remember, you cannot serve the defendant yourself. That's not proper service. I strongly suggest do not serve the defendant yourself, not with custody. Understand that until the defendant receives proper service, your case cannot be heard in court. You can, if you're asking for emergency custody, you can do it ex parte, which means that you go without the other party having notice. But again, that is only temporary. And once the defendant is served, it has to be put in front of the judge within a certain amount of days, usually 10 days, to be heard. Remember that the defendant has 30 days to answer when he or she receives the documents. Now that 30 days can be extended if the defendant makes a motion for extension of time. And if they make that motion for the first time, they get an automatic 30 days. That's whether you agree to it or not. That's the law. If they ask for extra 30 days, they can get the 30 days the first time. The second time, they have to ask permission from the court. The defendant may answer with or without counterclaim. So they may just do an answer, responding, admitting, or denying what's in your complaint. Again, if they file a counterclaim, that is their complaint against you. But beware, sometimes defendants add extra things into the complaint. And some of these things they are allowed to do. If they do that, please seek the advice of a lawyer, because you may have to answer their counterclaim. What ways can you serve the defendant? You can serve the defendant by the sheriff, as we talked about previously, by certified mail return receipt requested, or by publication. Service by sheriff. Again, the sheriff will need 1 white, 1 yellow summons, your complaint, your minor child affidavit, and mediation papers after they have been filed. The clerk may have a sheriff box once again, and they will put those documents into the sheriff's box for you. But if they do not, you will have to take it to the sheriff's office, and these are the documents that the sheriff will need. 1 white summons, 1 yellow summons, the complaint, the minor child affidavits, and the mediation papers. Again, if the petitioner sued for waiving court fees is not approved, you will need to pay by cash or money order to the sheriff's department in the county where the defendant lives, not where you filed necessarily, but where the defendant lives. And generally that fee could be $30 to $50. If the petition to sue is granted and your fees are waived, the clerk can write on the summons, fee waived, and you will not have to pay the sheriff's department to serve. Your fee is waived. That's again, if you file a petition to sue and it is approved. What will happen? Once the sheriff serves the defendant, he will send or she will send the clerk a copy of the completed summons. They will send back the white summons. The back of the summons will be filled out, or the second page of the summons will be filled out of when the defendant was served, how the defendant was served, and they will send it back to the clerk's office. I suggest give the sheriff at least 1 week to serve the documents, and then call the clerk to see if the summons have been served and when. Remember, the defendant have 30 days after they receive the documents to file his answer or counterclaim. You should not file to have the case heard prior to that 30 days. You can do the mediation before the end of the 30 days, but to go in front of a court, but go in front of a judge, you cannot go before the end of the 30 days. Another way you can serve the defendant is by service by certified mail, return receipt requested. When you use the mail, you only send 1 yellow summons, not the white one, 1 yellow summons, the complaint, minor child affidavit, and mediation papers. This is a good option if the parties lives out of town and or out of state, or if the sheriff is unable to deliver the summons to the defendant. You will send it to the defendant's home address, return receipt requested. Check on that box on that green card, return receipt requested. Make sure on the back side you put your address and your information so that the mailman can return the green card once it is signed by the defendant. If you need help, most postal workers are very gracious and will help you get that filled out. So when the green card comes back to you in the mail, fill out the affidavit of service by certified mail and attach the green card and sign the affidavit in front of a notary. Okay, so now we're after the filing and the defendant has been served by certified mail. You will need you will need to file an affidavit of service or process. And this is also found on the nccourts.gov website. Go under forms, type in affidavit of service or process. And this form will come up, and you now have a file number because you filed your case. So whatever, you're going to use the same file number on every document that's pertaining to this case. Check district, check the county in which you filed, your name, defendant's name, and then you're going to check this box right here that says certified mail. I'm not sure if this is in your packet or not, but again, you can go and get this off of the nccourts.gov website. Then you fill out, how did you mail it? You mailed it by certified mail, return receipt requested. And what did you mail? A copy, summons, and complaint. And you're going to check in other documents. You're going to put mediation forms. And if you have affidavit of minor children, you put that as well. Whatever you sent the defendant, you need to let the clerk know and the courts know that these are what I sent to the defendant by certified mail. And this is what, and that they did receive these things. And then you're going to fill out in the above caption action 2, and you put the defendant's name and the address in which it was served. And then you're going to check this box, the copies of the summons and complaint and the above listed documents were in fact received by the defendant. And on that green card, it will be a date or a stamp in which the defendant was served, on the date that the defendant was served, as evidenced by the attached original receipt. And on the affidavit, there's a big, white, clear part of the paper. You can staple or tape the green card. So you just need to attach it to the front of this affidavit and then take the affidavit to the notary and sign in front of the notary. So this is another paper that you will have to have notarized after filing and after service of the defendant. This is when you receive the green card back. If you decide to serve by certified mail, return receipt requested. The last way to serve the defendant is by publication. And this is absolutely the last resort. This is if the sheriff can't serve them, certified mail does not work. And you really kind of just don't really know where the defendant may be, you can serve by publication. But let me tell you, it is best to get the help of an attorney, even if it's just for service. Because the service must be published in a local newspaper for a specific amount of time with specific wording, and it must be where the defendant's last known whereabouts. This can be very costly, and the fees are not waived because the courts do not have anything to do with publication. Some courts will require you to come to court and show that you have provided due diligence in locating defendant before publishing. Some courts are going to ask you to run a vehicle report to see if you can find them that way, or a criminal background check to see if you can see where he last or she last lived, and if you use that option. So it is best really to get a help of an attorney if you are not able to get the defendant served by certified mail, return receipt requested, or by sheriff. So this next part is just really talking about what we've talked about before. What is mediation? And that is the process in which a third party that is neutral will help parents develop an agreement concerning custody and visitation of their child. And it's an informal forum to discuss parenting issues prior to trial. There is an orientation session followed by informal confidential meetings with the mediator. And the mediator, if the parties do come to some type of agreement, will type up a parenting agreement, give the parties about 10 days to review the agreement. And if they still are in favor of it and there's no changes, or if the changes have been made and everybody is still on one accord, they come back, sign the parenting agreement, and then the mediator takes it to the judge. And the judge will look over the mediator's parenting agreement, and if they agree with it or feel that it's comprehensive and is workable, then the judge will sign it. And then you will have a court order. And that basically ends your process of having to come to court in front of a judge, because now you have an order. The parenting agreement, once it is signed by the judge and filed, is a court order. The mediation cannot happen until after the defendant is served. It can be before the 30 days is over, but it cannot happen until after the defendant is served. Mediation is generally, again, mandatory in all cases, except where there's been domestic violence or if one party lives over 50 miles from the courthouse. Understand that with the time and ages of now, the judges may send everything to mediation or send custody to mediation because of the availability of internet use and WebEx and Zoom and virtual meetings where the parties do not have to be in the same area or room at the same time. Just remember, during the mediation sessions, be cordial during the sessions. The first session will be an orientation, and that will give you more information on what to expect. So you'll watch a video, it'll tell you about what mediation is, what to expect, what the mediator can do and cannot do, so that everyone will go in and with the same idea of what's going to happen. Most of the time, the orientation is separate than the actual mediation. And so you'll have an orientation. There may be a number of people on the line or on the Zoom call or at the orientation. And then the mediator will follow it with you specifically and try to come up with a date that you and the other party can actually have the mediation. Before you go to mediation, write down what you want. What are your expectations? What would you like to see happen? But at the same time, be flexible and willing to listen. Just an idea of what standard visitation is: every other weekend, alternating major holidays, and 4 to 6 weeks in the summer. So you kind of split the summers in half. Again, the mediator is just the person that's going to help the parties consider what to consider in making a parenting agreement in which both parties can hopefully live with and is in the best interest of the minor child. So the last part is, what if mediation fails? What now? Understand, all is not lost if you just can't come to an agreement with the mediator. Sometimes agreements still come after the mediation, but before you go in front of a judge. So an agreement can be made at any time during the trial. I have even had a trial, and before the judge can make his or her ruling, I had where the parties came to an agreement and the judge signed off on it. So an agreement can still be made outside of court, outside of having the hearing, or before the judge makes his or her final ruling. So don't be in despair. However, if you still cannot come to an agreement, you will have to go in front of the judge. And what will happen is the mediator will send a paper to the court saying the parties could not come to an agreement and that it needs to be set in front of a judge. And that's okay. Like I said, you can still make an agreement outside of the court, outside of hearing, but this just lets the clerk know and the courts know that the parties tried, but it didn't work. And so it does need to be set in front of the judge at some point in time for the judge to either review the agreement that you made outside of mediation or outside of court, or for the judge to hear testimony as to what is in the best interest of the minor child. So you go to the clerk, and the clerk can give you a few dates in which you can set your hearing on. You would need to file a notice of hearing and or a civil calendar request if that is required in your local setting. The clerk can tell you that you need to file a notice of hearing and a civil calendar. That's all they can tell you. And they can actually maybe even say, go to nccourts.gov, that famous website, nccourts.gov, to get a copy of the local calendar request. Each county has different things. Some counties may have a blank notice of hearing for you to pull. Some counties do not. Some counties have the civil calendar request. Some counties do not. So this is where an nccourts.gov could be very beneficial, in which you can go to your specific county and see what their local rules and forms require. Once you fill out the notice of hearing and civil calendar request, you mail a copy to the defendant's last known address. Usually this is what's on the summons, the notice of hearing and or calendar request. You send this by first class regular mail. You do not have to send it by certified mail. You do not have to send it by publication or by sheriff. You can just put it in the mail. There will be on the forms a certificate of service saying that you in fact did do this. So this is a sample of a civil calendar request that you may see on online for one of the counties. And this is a sample notice of hearing. You notice that it is blank because it is for someone that is filing pro se. So this is what a notice of hearing sometimes look like. There are some counties, if you go to their local forms, will have the notice of hearing and calendar request all on one form. Some counties keep it separate. So it's just best to know what your county in fact needs. But in the end, if you can type and you can type this up, then that county may take that notice of hearing form or calendar request. So let's talk a little bit about preparing for a trial. When you're preparing for trial, meaning you and the other party just can't get along, you're not coming to an agreement, you want to start gathering your witnesses. Who can testify about your ability to care for your child? And you will want to make sure that this witness does not have an extensive criminal history, in particularly one that involves forgery or some type of dishonest crime, like forgery, fraud. It's really just best to try to avoid someone that does not have a criminal history. But you want to start gathering your witnesses. And when I say gathering your witnesses, they will be willing to come and testify concerning your character, your ability for your child, and they are willing to come to court, not just simply write a statement, because that might not fly with the court because it would be hearsay. But these witnesses, they know your court date. They're coming to court with you on your court date. You will want to start getting your evidence that support why you are the best parent and you can provide for the best interest of the child. That could be showing the courts some of the activities you do with the child, showing the court the child's room in which he or she lives in and the home in which he or she lives in. You can bring family photos, school records, medical records. If your child has an IEP or other school documents, you can bring those along with you. If the other party has a criminal record, get a certified criminal record. And then make a list of what you want the judge to know. It is easy to forget important details during the trial. So I encourage you and suggest that make a list of, I want the judge to understand, or I want the judge to know, that I am the best parent because A, I've always taken care of this child. And list what you would show to show that. It also helps you to stay focused. Your focus is what is in the best interest of the child. Your focus is not trying to throw the defendant under the bus. It's not trying to make the defendant look as bad as they can look. That's going to come out in the wash. Your focus is letting the judge know that the best interest of the child is with me, and that is because. On the day of trial, dress conservatively, professional attire. Be on time. The courts do not have to wait. If the court started at 9 o'clock, be there at 8:45. The courts do not have to wait beyond 9:01 to see if you're going to show up for court. If your case is called at 9 o'clock and you're not there, the courts can dismiss your case, or they can grant the defendant whatever they ask for in their counterclaim. So make sure that you not only be on time, but you keep track of all of your court dates. No drugs or alcohol before or during your trial. Always tell the truth and keep your temper and composure. Stay cool, calm, and collected. Just go in expecting that the other party is not going to tell the truth. So the judge don't need to hear you hemming and hollering every time they say something that's not true. Just be ready to counter it with questions and or evidence of your own. When you're testifying, stay calm, speak slowly, speak clearly, make eye contact with the judge. Don't be in a rush to try to answer questions. Don't let the defendant try to rush you. And remember, there are no juries in domestic cases. The judge is the jury. Stay on the issue of custody. Again, focus on what is in the best interest of the child. Do not be tempted to start talking about disagreements with the other party or why the relationship did not work. The judge could care less. So after the hearing, the judge will make a decision. Sometimes the judge may say, I need to think about it and review my notes, and I will send the order to the parties. If that's the case, then the judge will recess your case until he or she makes that order. In most instances, the judge will make a decision verbally in court, and he will call that the order. Now, the order is not into effect until the judge signs a written document stating that it is the order of the court and it is filed with the clerk. Understand that you must comply with the order, whether you agree with it or not, because if you violate the order, the courts can punish you and hold you in contempt of court. They can put you in jail. They can actually reverse the decision and give the other party custody or do something different. They can make you pay a fine. So there are different things or avenues in which the courts can hold you in contempt and punish you. You can, if after some time goes by, request for a modification of the order, but you will have to show that there is a substantial change in circumstances that affects the welfare of the minor child. So just a little briefly about the COVID-19 in the courts. The courts have expanded their operations. They are fully operational as of right now. It is suggested that you go to nccourts.gov and see if there's any changes with your courthouse procedure or what have you. I believe face coverings may be required in some courthouses, but again, check with your county so that you can make sure that you are indeed able to have access to the courthouse, or they could turn you away if you do not have a mask or you're not following their mandates. And again, you can go to nccourts.gov to get court updates and whether or not your courthouse has any issues or closings. So that's the end of the presentation. I know that was long, but I thank you for hanging in there, and I want to wish you good luck. If you feel you need further advice or help, you can call our legal aid helpline, or if you have other issues that we talked about in the very beginning that we cover, you can call the legal aid helpline at 866-219-5262, or you can also apply or find more information on legalaidnc.org. If it is something that we've previously talked about, or if you're looking for more help with your custody complaint, or if it's something that we do not cover, I do suggest going to the lawyer referral helpline or the lawyer referral line at 1-800-662-7660, and they will give you a reduced consultation fee for $50 for 30 minutes.
Okay, perfect. So we're gonna open it up for questions. If you're watching on Zoom, you can put your question in the Q&A. And if you are watching on Facebook, you can put your questions in the comments. We do have quite a few questions, so we're just gonna jump right on in. I'm actually gonna turn on the recording for this, so just give me 1 second. Okay, perfect. So let's go on. The first question says, how do you file an emergency custody? What form do I use for that?
Okay, so there are no forms for emergency custody. You will need to, as stated in the presentation, add into the complaint a line that says that the defendant is unfit. If it's a new custody action, the defendant is not fit to have the care and custody of the minor child, because one, the child will be in harm's way with the defendant. 2, the defendant is not stable. Any other reasons that you feel that will cause the child to not thrive or to be in harm's way, or if the defendant is going to try to run away with the child. There are no specific forms. You will have to add it on to the complaint.
Okay, perfect. The next question says, do you have to have a lawyer to change/modify a child consent order?
You do not have to have a lawyer, but you do need to understand that modifying a child custody order does have some specific languages that need to have in it, such as that there is a substantial change of circumstances that affect the welfare of the minor child. And that substantial change could be good or bad. Most of the time, it is something that is negative to the child, but you would need to put that into a motion to modify.
Okay, perfect. The next question says, so if someone had a previous case that's now closed, if they file a petition/appeal, do they have to file in the county where they first had the case, or can they file in the county that they live in now?
If there is already a custody action started and the child is still under 18, then you have to go back to the county in which that custody action has been filed and reopen that action. You do have options if neither parent is living in that county any longer. You can ask the county to, or you can ask the judge to change the venue to where one of the parties or the child lives.
Okay, perfect. The next question says, do you have to go through mediation before court to change an existing child consent order?
Some judges, yes, prefer that. If the parties cannot agree to the modifications of the consent order, and there has been some time Since that order has been entered, the judges generally do order the case back to mediation before they even do a modification.
Okay, perfect. The next question says, how can I get visitation and other things legalized without going to court?
If the parties cannot agree, then there is no other way than to go to court and ask the judge to assist you in getting visitation.
Okay, perfect. The next question says, what if the parents live in different states? Does that mean one parent has more rights?
Not necessarily. If the parent lives in North Carolina and the child is in North Carolina, then basically that just really means that North Carolina will probably have jurisdiction over the minor child. It does not necessarily determine which parent has more rights than the other. The judge can very well rule that the parent in the other state would provide the best interest of the child and order that child to go live with that parent in the other state.
Okay, perfect. The next question says, does Medicaid count as a way to get the filing fee waived?
It does not, but I would suggest filling out the Affidavit of Indigency, which is another form that the clerks have to show that you're unable to pay to have the fee waived.
Okay, perfect. The next question says, so someone moved and left the kids with the dad. And then while they were gone, the dad got full custody. And they're not able to contact them or talk to them. What are the next steps that they can take?
Well, I would say generally, if there is a custody order, then that other party or that other parent would need to file a motion to modify that custody order if that party does not have visitation or any other rights in that order. If it does give that party visitation or other rights and the other party is not following through with it, then a motion to show cause, which brings the other party in front of the courts to say, why are you not following the order?
Okay, perfect. The next question says, what if there are more than one defendant?
If there are more than one defendant, then you just list both defendants. And the civil summons give places for that. Well, all of the documents that are on nccourts.gov gives room for that, or you just simply type in or write in both defendants' names. On the complaint, you just simply type both defendants' names.
Okay, perfect. The next question, we actually have had a couple questions like this. So what happens if the defendant does not have an address or is homeless?
You still have to try to get him or her served. So always start with the last known address and see if that works with getting the person served. If that does not work, if the sheriff is not able to get that person served, then the only other choice you would have is with publication. And I suggest going to nccourts.gov, look in the county in which you're filing, and go to that county and look at their local rules and forms, and see if there's a local rule about publication, or see if you can contact an attorney to ask for assistance in getting the publication done. And that attorney should be able to walk you through or help you. Of course, there may be a fee in getting the publication done.
Okay, perfect. The next question says, do I need to include the Civil Relief Act paper if if neither one of us is in the military?
Yes, that is a paper that is mandatory whenever there is a filing, especially a new filing. And if neither one of you are in the military, there is a box that says that the person is not in the military. And then you have to state why you know or how you know that person is not on active duty or in the military.
Okay, perfect. The next question says, if there is already a temporary custody order in place and going forward, will the file number be used or will another file number be given?
The file number will always be used concerning custody of this child, of that child or children. So no, if you're filing any documents concerning that child in that county, you will use the same file number.
Okay, perfect. The next question says, if both parties are in agreement on a custody agreement, do you still file that form?
Yes. If you are in agreement and there is a custody action already started, then you file that agreement and ask the judge to sign off on it so that it can become an order. Unless the parties are pretty cordial, you don't think that there's going to be anything down the road that's going to happen, then it could just be a contractual agreement. But otherwise, I would suggest having the judge sign off on it and having it filed so that it will be in order.
Okay, perfect. The next question says, what if the defendant lives in another country?
If you do not have the address or able to serve it by certified mail to the other country, or even by FedEx or UPS where it can be registered mail, then I would suggest contacting a attorney that can help you get international service.
Okay, perfect. The next question says, how can a parent file custody of a child when they live out of the country and the child lives in North Carolina?
If the parent wants North Carolina to have jurisdiction or they are willing to come to North Carolina where the child is living, then they would just follow the same procedures and have the complaint and everything filed. You can do it by mail, by sending the documents to the clerk's office in the county in which the child lives, and then having them send back the forms once they are filed, and then you can have them served as you see fit to have it served.
Okay, perfect. The next question says, how do I go about finding an attorney that will accept payment plans or deferred payments?
I would say go to the lawyer referral service that was on the last slide. They do generally give a reduced fee. When you contact the lawyer's office, you can ask if they help with, or they give you a payment plan, or if they have any waivers of any of their fees. Most of the time, lawyers will let you know that up front of how much it costs and whether they will be willing to assist you in setting up a payment plan. There is no list as to this lawyer gives payment plans, this lawyer does not. So you just have to kind of call until you find one that you're comfortable with and one that will give you a payment plan.
Okay, perfect. And also, can you have the last slide up on the screen so people? Thank you. Okay. The next question says, If there is a form for both parties voluntarily being in agreement, does it need to be notarized?
Yes, most judges prefer that if there is no attorney signing off on it, or if it's signed out of court, out of session, that the documents be notarized, the agreement be notarized. Mhm.
Okay, perfect. The next question says, if there are other factors such as therapists recommended that the parents not see the children, can mediation be waived?
Generally, mediation, that is not one of the factors for mediation being waived. It is something that you do want to let the mediator know, and then the mediator can make the call as to whether to proceed or to go ahead and just order it to court in front of the judge. So definitely let the mediator know that. And they have the authority to say this is not a good case to go to mediation, and just go ahead and send it straight to the courts.
Okay, perfect. Sorry, I was just, sorry. The next question says, so I wanted to know about moving away law. So this person wanted to move out of North Carolina. Do they need the other parent's permission to move with the children?
Generally, you do not need permission to move. You have a right to live where you want to live. However, if the other parent is not in agreement with that, and they can sue and bring you to court to either get custody or to get some type of arrangement set up. So it depends on if you and the other parent are in agreement with you moving. But you're free to move wherever you are, but that does not keep the other party from accessing the courts for assistance.
Okay, perfect. Okay, they just asked. The next question says, do we have to do mediation if we agree on everything?
You do not have to do mediation if you have everything agreed to and it's typed up. You could just bring it in front of the judge and have the judge sign off on it and have it filed, and then you have the order.
Okay, perfect. The next question says, can I file a visitation complaint for the other party refusing my visits?
If there is no order, then yes, you can file a complaint for visitation. If there is an order that gives you visitation privileges and the other party is still refusing, then you need to file a motion to show cause and request the courts to find whether or not that other parent is in violation of that order, and seek the assistance of the court in getting that order enforced.
Okay, perfect. The next question says, am I able to file for custody if I have already filed and been awarded a visitation?
You can, if you already have a visitation order and you want to modify the order and seek custody, then you would need to do a motion to modify and show the judge why there is a substantial change of circumstance in which you should now have custody of the child.
Okay, perfect.
Yep, you do not have to start all the way back over with filing the initial complaint. You just do a motion to modify.
Okay, perfect. The next question says, if I am revisiting custody due to an out-of-state move, do judges favor the household staying in state for custody?
So if you've moved out of state, It depends on the reason why you moved, and whether or not the other parent is still having the same access to the child for visitation. So it's really going to fall down on the lines of whether or not it's in the best interest for the child to either not have as much visitation, or whether or not the child is getting the visitation with the parent that is still in state.
Okay, perfect. We already answered that. The next question says, will witnesses from the family be of value if from your side, or more valuable if from the defendant's side?
Families are always valuable. And I can't say whether one is more valuable than the other. It just really depends on each family's dynamics and circumstances. It's really going to boil down with your witnesses as to credibility. Of course, it does strengthen your case even more if the witness is from the other family side. However, that is not that's not necessary if you have witnesses that are credible in your family that could come and testify as to, you know, how you care for the child and your character.
Okay, perfect. The next question says, what if someone just wants shared custody because the other parent won't allow any kind of visitation?
That would be a great opportunity to go in front of the judge and file a complaint if you are being denied access or visitation with your child. Sometimes other parents just need a little prompting. But if the child is not going to be harmed in one parent's custody, then that parent still have a right to be able to be a part of that child's life and help raise that child.
Okay, perfect. The next question says, is serving the defendant at their place of work an option?
It can be an option if you it can be an option. It's not the best option because the statute specifically states at their residence, and it really depends on the job and whether that person can be personally served. It is an option that is used if you don't know where that person is living, or you know they're not going to pick up their certified mail.
Okay, perfect. The next question says, can I serve an incarcerated parent via certified mail?
Yes.
Okay, perfect. The next question says, if there's no previous custody order and both parties are in agreement, can you type up a written notarized agreement and take that to court to have the judge make it a permanent custody agreement?
Generally, you would need to file an action, and some attorneys do a friendly action that just says, I'm filing for custody and visitation, and then have the parties enter their agreement right after the filing. But you would definitely need to have something filed so that it can go into that particular court file.
Okay, perfect. The next question says, for a military service member, are prior deployments held against them if the children were with the defendant each time? And if so, how can you counteract that?
Prior deployment should not be held against a party. I think judges will more than likely see that as service to his or her country. And I think what the judge is going to basically really be looking at is stability. When the person comes back, and the relationship between the child and the person that had been deployed before. But I have not seen or do not know of a judge that will use prior deployments against a military personnel.
Okay, perfect. So the next question says, what if you have an open case and the other parent is not following court orders?
If there is an open case and the party is not following court orders, you need to file a motion to show cause. That is something you would have to type up yourself. There are no forms that I can recall that are on the website.
Okay, perfect. The next question says, what documents will be needed for a National Guard service member filing as the plaintiff?
If you're in the Army if you're serving the country, you file the same documents. There's nothing different.
Okay, perfect. The next question says, if you expect the defendant to use false claims about you, how best can you deal with the allegations?
One, if the false claims are in the complaint or the counterclaim, you can respond to those by admitting or denying those allegations. And then just being able to get your evidence to show that those claims are not true when it goes in front of the judge.
Okay, perfect. The next question says, if you file for an absolute divorce and we hire a lawyer, do we have to attend the court date?
That will be something your lawyer would have to answer.
Okay, perfect. We already answered that. The next question says, if a maternal grandparent files for custody, is it a good idea for the other side grandparents to file in order to get visitation as wanted?
If one set of grandparents is filing, it's going to be against the defendants. If the other grandparents want to become a part of that action, they can intervene, meaning that they can file their own documents within that same court case, asking the judge to allow them to be a part of the action so that they can receive some type of custodianship, whether it's custody or visitation. So there is a method to intervene into a custody action that is already instituted.
Okay, perfect. The next question says, so basically the passport office says that this person can't get their child a passport without the father's consent. Would they need to file for sole or legal custody?
If there is no custody action, you can file for a custody action and then ask the courts to order the other party to sign the passport. Or if that does not work, then the courts can enter an order allowing the passport to be issued. I would really highly recommend getting an attorney to help with that, to navigate all of that, because it could take some time.
Okay, perfect. The This next question says, if there's an 80-20 schedule, does it have to be a permanent schedule, or will the courts allow a month-to-month schedule?
I think it will have to be determined what would be best for the child. And all orders can be temporary. Just understanding that even if it's temporary, it can eventually become permanent under the right circumstances. And so even though the court may order in that instance a temporary order saying that it's going to be 80-20, unless the parents bring it back to have it changed or to have a hearing, then it could essentially become a permanent order. I'm not sure about whether a judge will say we're going to review this month to month, because then that's going to require the parties to continue to keep coming back to court month to month.
Okay, perfect. The next question says, can I stop a lawyer from postponing court dates?
I don't think so. You can certainly object to it and have a basis for your objection, but it's really left in the discretion of the judge as to whether or not the case needs to be continued.
Okay, perfect. The next question says, what is a contractual custody agreement, and can that avoid court involvement if both parents are in agreements?
Right, so if you just have a written agreement, that will be fine. It's not enforceable by the courts unless you bring it under a contract claim or you file a custody action and then have it entered into as an order. But if the parties are in agreement and they feel comfortable that the parties will follow the contract, then that's perfectly fine. You don't necessarily have to go to court if the parties are in agreement. I would suggest that until the parties fall out of agreement, if that ever happens, or you just can't sit down and come to a reasonable agreement or modification of the contract, then seek the assistance of the court. But I would say if the parties are in agreement and they'll write it down and they have it notarized, then that's a contract between the parties. And until something happens where the court has to get involved, that's fine.
Okay, perfect. And I think that kind of starts to answer the next question, which is asking where to find files/actions to get started on a mutually agreed custody agreement.
There are no forms for that. That is something you would have to type up on your own. You can ask an attorney to see if they will be willing to send you a blank copy of something or a sample, but there are no forms readily available on the nccourts.gov website as to a custody agreement.
Okay, perfect. The next question is a follow-up to the maternal paternal grandparents question. And then it's asking, how do the other grandparents submit for intervention with maternal grandparents? Is there a form?
There is no form, and they would probably need to contact an attorney.
Okay.
Because that's a different kind of form or a different kind of pleading that would need to happen.
Okay, perfect. The next question says, so a child has been placed with their paternal grandmother and they're not following the visitation guidelines. Will there be any way to have the grandmother follow the visitation guidelines to maintain the mental health necessities of the child?
If a party is not following the order, then you need to file a motion to show cause. And ask the courts to determine whether or not there was a reasonable basis for that party not following the order. And with that, the courts can then determine what would be the next step as far as either modifying the order or holding the party that's not following the order in contempt.
Okay, perfect. And the next question says, the defendant refused to let the child see their father and she blocks them on social media. What can we do to get child custody?
File a complaint. If there's no complaint, if there's no order, you need to start an action so that the judge can, or the parties can either come together or the judge can determine what type of custodial or visitation arrangements need to be ordered.
Okay, perfect. The next question says, what is the best way to show unsatisfactory conditions of one of the homes? Would pictures be the best way?
If you are able to get pictures, yes.
Okay, perfect. That looks like all the questions. I'm just going to take a second in case anybody is typing. I'm going to use that to say that if you're watching on Zoom, we will be sending out a follow-up email that will have a link to this presentation, as well as a PDF copy of the slides. If you're watching on Facebook, we don't have your emails, but this video will be on our Facebook page indefinitely. So if you go to our Facebook page, facebook.com/legalaidnc, and click on the videos tab, you will be able to find this presentation as well as previous presentations to look through. And that should be up there indefinitely. And I'm not seeing any more questions. So thanks so much, Dietrich.
Thank you. Good luck, everyone.